Welcome to the Binary Agora. I am your host, Alba Rivera Martinez, and some episodes back we had with us Victor Fernandez, then commissioner at CAGI, to explain the Brazilian proposal for a digital markets regulation, which was quite similar to what the UK now has introduced as the DMCCA. And a few days ago, the Brazilian legislature decided to amend the content of that initial draft. So to consider the latest amendments and developments that have taken place during the legislative process, I have with me today Rafael Rossini Parisi. He worked for 4 years as a chief of staff to one of the commissioners at CAGI's tribunal, and is also now an attorney and public policy professional with extensive experience across competition law and regulatory enforcement. So welcome to the Agora, Rafa.
Thank you so much, Alba. I've said this many times off the record, but I'm gonna say now this on the record. I'm a big fan. I'm a listener of the Agora myself, so I received this invitation with great pleasure. It's an honor to be here, and looking forward to our conversation.
So to start the conversation going, I wanted to ask you first to briefly summarize what the Brazilian digital markets regulation proposal is trying to deliver.
Yeah, sure. So as you said, I know there was already an episode on this with Victor Fernandez, so I'll be brief here. But I do think it's important to mention a little bit about the context, right, surrounding this bill. I think a few years ago, Brazil was discussing whether digital markets should be regulated or not. I think now there is a greater consensus that the question is more when and how rather than whether. So we did have in Brazil a first bill proposed in 2022, which was inspired at the DMA, but it was a simpler bill. It was a shorter bill, in my view, not so sophisticated, that I think raised more questions than answers. And there weren't that many developments regarding that bill in Congress. There wasn't like a sign that bill had been previously discussed with civil society and also with other branches of government. However, this other bill that we are discussing right now, this bill that was proposed in September last year, 2025, this one indeed, there are great signs that it was a result of a very comprehensive discussion between civil society and the government. It was proposed by the executive branch of the government itself, following a very detailed study conducted by the Ministry of Finance in Brazil that gathered the views and contributions from many different sectors, from companies, from the academia, from civil society more broadly, including CAGI. And it was the first time that CAGI spoke loud and clear that it was supporting ex-ante regulation in digital markets. So it was a groundbreaking event in terms of the regulation of digital markets in Brazil. With these new changes, the structural design of the bill with these amendments didn't change, meaning it's a bill that just aimed to change the current Brazilian Competition Act, which is law 12529 of 2011. So it's not a whole new statute like the DMA, for instance, and the DMCC. So it's approach more similar to the approach adopted in Germany. However, it has some influences you can see from these other regulations that were proposed and enacted abroad. So for instance, many of the obligations do have an inspiration at the DMA. Also the objectives of the law, you can notice, for instance, that the amendments, they mention that the objectives of the law should be to promote the freedom of choice, also the reduction of entry barriers and the protection of the competitive process, which in my view, they resemble a little bit the idea of contestability of digital markets that is embedded in the DMA. And it's interesting to note here that with the amendments now, the order of these objectives changed. So it's interesting to see if this change in the order, now the first one of the principles listed is the promotion of freedom of choice. And this was not the case in the original wording of the bill, followed by the reduction of entry barriers and the protection of the competitive process. So it's interesting to see why this change occurred and if it's just a more like format style thing or if it's going to have a more meaningful result. So So I think there is this influence from the DMA, that influence from the German law, and I think most notably it's worth to mention the influence of the DMCC, because differently from the DMA, this bill in Brazil prescribes tailored special obligations to each gatekeeper. The technical term used in the bill is economic agents of systemic relevance in digital markets. Quite a long terminology. Instead of adopting an all-inclusive type of obligations to all gatekeepers, instead this bill proposes tailored obligations to each gatekeeper. So it's a customized approach tailored to each company.
Okay, that's really good to know. And actually, you mentioned this that there have been several iterations of these amendments since 2022. Now we have seen that the 2025 version has also been substantially amended. And I was wondering, why did you say that now you have the feeling that more of the civil society, academia, industry has been listened to and accommodated their views into these new rules that have been proposed? And given that there are so many changes going on with regards to how the legislative process advances and develops, what would you say that is the provision that you'd flag as most likely to change again before this becomes actually law?
Yeah, I think it's a great question and difficult to answer because, right, we never know how these changes come and go. The legislative process is very hard to predict. And we do have an interesting also aspect going on in Brazil, that this year we have general elections in Brazil. So even though this bill was received like an urgency treatment in the Brazilian House of Representatives, meaning that it became a priority and it can be voted directly by the plenary of the House of Representatives, which is different from a traditional law that didn't receive this urgency treatment, that first needs to go through a different committee and then it would be voted in the plenary. So with this urgency treatment that the law receives, it means it can be voted anytime. So this week, we never know, in a few months from now. So it's very interesting to see, and according to like news coverage, we see that the ones supporting the bill, they want to get it done as soon as possible because the Brazilian Congress is going to enter in a recess shortly, I think in later this month, and it will come back to its work shortly before the elections. So we know the timing is going to be very delicate. There is this pressure for this bill to get voted as soon as possible, according to those that are in favor of it. Of course, on the other hand, those that are not in favor of it, they want to postpone the voting of this bill to after the election. So it's going to be interesting to see how these legislative events will unfold. But yeah, you mentioned about the civil society support, right? And I think it's interesting to see that even though, again, like I said, we are talking here about mere amendments to the Brazilian Competition Act, we can note that the Brazilian government has enacted several different types of laws, not related to competition policy, but also aimed to target the digital markets. I think one very notable example is the digital statute of the child and adolescent, which is the law number 15/211 from 2025, which entered into force March this year. Basically, it modernizes the country's original child protection laws by establishing safety by design regulations for digital companies. There are other examples, other laws, other presidential decrees. So I think this bill is part of a broader regulatory agenda to address the concerns that society has over digital markets in general, not only related to antitrust, but antitrust being one of them. And I think a second reason that shows this support that civil society has over this bill is like I said, the great like transparency and also social participation that preceded the proposal of this bill and also that followed the discussions surrounding this bill. So many other cases were brought by CADE. There was the Apple Store case. CADE has also conducted like public hearings, which was a very innovative dynamic that it was something rare in the past. So we can see that society in general is being more actively involved in the discussions about this topic.
And so in terms of designations of these economic agents of systemic relevance to digital markets, so the current version that now has been tabled has now dropped some of the criteria that would apply to the process. It has also added a review process and also shortened the designation period from 10 years to 6. So I wanted to ask you, within this comparison between the two versions, do you believe that these amendments entail that it is harder or easier in practice for a platform to get designated?
Another great question. And I think the changes, they point towards different directions. We can note that some of the changes, in my view, they made the designations harder. But on the other hand, in practice, they may allow more designations to happen. And let me explain. I think from a substantive point of view, in terms of the legal provisions themselves, regarding, for instance, the criteria, the original version of the bill mentioned that basically CADE could consider one among many examples of characteristics in digital markets in order to designate a company as an economic agent of systemic relevance. Now, the bill mentions that CADE must consider several aspects in a cumulative manner. So it's basically narrowing it down, the power, I would say, of CADE in order to do like a brainstorming of what criteria it would consider. And at the same time, it mentions that CADE should take into account this broader set of characteristics. Instead of like focusing only on one, now it should consider all of these different aspects. So I think from this standpoint, one could say that it is more complicated because I think the decisions now should be more legally founded, right? On the other hand, we can also note some examples of changes that in practice may make designations more likely to happen. And I think these are not like from a legal perspective, but more from like a practical perspective. So for instance, you mentioned the reduction of the duration of the designations, right? Now they take like 6 years. Also, the amendments now bring the possibility of these designations to be reviewed in 2 years. This was something that the original text was silent. And not only the designations, but also the determination of obligations. So now every 2 years, CADE may review whether these designations or these obligations should stand. And I think since now the time frame is shorter, I think this probably take away a little bit of the weight to CADE when designating companies or when imposing obligations. So maybe this in practical terms could give more comfort to CADE and encourage CADE to proceed as such, because it will know that, okay, maybe if this designation was not accurate, or let's say it was accurate, but if in 2 years the market changed a lot, we can review and we can revisit this designation and change it, right? And take it away. So there are like some mixed changes that point to different directions. So I'm also curious to see in practice how these changes will play out.
And a brief follow-up on that, because I have the English unofficial translation of the text. So you said, if I understood correctly, that CADE may perform those reviews on designations and obligations. Is that a possibility? Or is CADE forced to do this every couple of years?
Yeah, what the changes say is that in 2 years, if like circumstances justify, a new proceeding can be launched in order for CADE to review and change these obligations. So it's not like an automatic review, but there is the possibility of these reviews to happen.
Okay, because for instance, this distances itself from the DMA, which actually compels the European Commission to review, for instance, its a designation of CPSs every 3 years, or to review or to actually conduct a fully drawn review on how the obligations are doing. So that's good to know. And aside from designations, the amendments have also touched upon obligations. So there are basically 3 big groups of obligations that could be imposed on these economic agents of systemic relevance to digital markets, which are obligations relating to transparency, then affirmative duties and abstention mandates. And the abstention list grows to, for instance, explicitly prohibit dark patterns in interface design. So I think that this ties really well with what you were saying earlier, share in this interest by the legislator to welcome comments and feedback from civil society, also incorporate much more substance aside from competition policy into its enforcement. So I wanted to ask you, is this also expansion within its obligations a sign that lawmakers are now looking past antitrust and maybe towards something closer to consumer protection regulation, perhaps?
Yeah, I think yes and no. Let me explain. I think we have a difference in CAGI compared to, for instance, the CMA in the UK, that CAGI has an exclusive and very narrow mandate of only enforcing the competition law, right? So CAGI does not have a consumer protection mandate, which is different from many other antitrust agencies around the world. And Brazil follows a civil law system, so we have a very comprehensive statute that prescribes pretty well and narrowly the CAGI's competences, right? So I think CAGI's mandate will remain as such. We will remain focused on competition law, but I do think, going to the other side of my answer, I do think that the changes, they signal in a way that inevitably digital markets and the competition concerns, they related to antitrust, they do not operate in a vacuum, right? They are related, as is the case for dark patterns. They are strictly and inherently related to consumer protection aspects as well. So I think the law recognizes that, and that's why this new bill emphasizes a lot the role of cooperation between CAGI and different regulators. For instance, the Data Protection Agency, the Consumer Protection bodies as well, the other branches of the government. So there is a change in the bill in Article 47F, for instance. There is additional wording that says that this collaboration can happen with basically all bodies of the Brazilian government, including the state governments, the municipalities. So basically it says that cooperation can happen with everybody, right? With all regulators. And I think this cooperation will play a very, very vital role when it comes to making sure that all public policies are coherent, right? So the consumer protection policy with the data protection policy and antitrust policy. So CAGI itself will remain focused on enforcing the antitrust law, but I think this cooperation will play a great role, and I think the community can expect this cooperation to happen more and more.
And so a follow-up on that. So you're saying that cooperation is expected from CAGI to really crystallize with respect to how this new set of rules are going to apply, especially on the side of public policy, but you have worked extensively with, for instance, data privacy. So I was wondering whether you anticipate any of those frictions to materialize yet again when this set of rules are being applied with regards to how, for instance, data privacy and data protection are protected within the Brazilian territory, or do you anticipate that tension to be ironed out by this general principle of cooperation and coordination?
Yeah, I think this is also a good question, because at the same time that these different regulatory bodies acknowledge that they have to work together, this also raises room for more friction, right? And more like conflict in terms of who is in charge of what type of policy, etc. So I think it's going to be very challenging in practice to see how this law will be enforced. And yeah, I think the only way is for the authorities to actually like cooperate a lot and get together a lot. So the bill prescribes that also there is a secretariat within the Ministry of Finance that is also in charge of competition policy, but more focused on like advocacy and not enforcing the law. And this secretariat also will be able to report to CAGI if it finds out situations of companies not complying with the law. So the regulatory agencies will need to work together in order for these policies to be effective.
Okay. Also following up on that, because we had, I don't know if you could watch that episode with Sebastião Barros, which actually was about the exchange of confidential information. So I was wondering whether there's an actual legal basis by which these competition authorities with, for instance, data protection authorities or other types of authorities can exchange confidential information against themselves to try to, for instance, tackle these instances of breaches with the law, or is that not possible, for instance, as is the case in the European Union?
Yeah, I think in my view, this exchange of information between regulatory agencies in Brazil is easier to happen compared to
Okay.
what I've seen my humble experience in other jurisdictions. Of course, with all the reservations of the duties to grant protections to not disclosing this information publicly. But this happens because the regulatory agencies, and CADE included, they actually execute many like agreements between themselves. So these agreements are also even public. So CADE, for instance,
Okay.
has celebrated in the past many agreements with other bodies within government, whereby they make the commitments to exchange information, to report to the other body in case they become aware of a breach, of a regulatory or legal breach. So by means of these agreements, they are allowed to exchange information with all of the caveats that I mentioned earlier. But I do see these things happen in Brazil from a legal perspective.
Okay, we touched upon the differences between the two types of versions, but I also wanted to tackle the similarities between the two versions. Both versions allow Kaji to require the technological redesign of a platform's products, for instance, as a remedy. So, how do you really anticipate Kaji to actually verify compliance with something as technical, for instance, as an algorithm, or to conduct this type of interface redesign?
Yeah, I think you're touching on a very important question, which is like remedies, right? So I
Yeah.
think when it comes to these different laws targeting digital markets, I think people spend a lot of time in terms of discussing how gatekeepers should be designated, which obligations they should face. But in the end of the day, I think everybody's interested to see how remedies will be applied, right? And this is the most difficult part, right? The most intriguing part, which remedies will be applied and if they are actually gonna work, which is what
Yeah.
society is mostly interested about, right? In general, I do think that the changes are not like super substantive. And this is another sign why this intent to regulate digital markets, I think, is becoming more consistent in Brazil, because the changes are not, we talked a lot about the changes here, but this new wording compared to the initial wording, I don't see them like super different. The design is the same as we discussed. Both keep the creation of a new unit within Kaji to tackle digital markets, which is separate from the traditional superintendents. There are some procedural changes, but in the end of the day, I think the similarities are greater than the differences.
Mm.
But regarding the implementation and monitoring mechanisms, I do want to flag two interesting changes
Okay.
that the amendments are bringing that I think touch very well on that. And the first one is the possibility of companies to voluntarily propose compliance mechanisms. So this is something that initially the law was not mentioning, and now
Mm.
it does mentioning that during the investigation,
Mm.
companies can voluntarily approach CADE to propose technical standards and uh, technicality, so they can have this proactive approach
Mm.
towards compliance. And then CADE, of course, is not going to be binded to what the company will say, but it does need to take them into account. And when CADE decides whether to implement obligations, it must address them. So law expressly says that CADE, when issuing its decision, it will like take them into account and it will basically pronounce itself whether those proposals will be adopted or not. So I think this is very interesting because I think it will also help CADE to come up with a solution whenever it finds a concern, right? I think the law, it can be like good or bad, but the law itself doesn't touch on resources, right? On like the technical capabilities that enforcing a different set of regulations against digital markets entail in terms of like staff, tech resources, etc. So it can be a bottleneck, right? As we know, CAGI, of course, is a very solid authority compared to many jurisdictions, but it doesn't have the same number of employees as, for instance, other authorities. So it's going to be very challenging. And I think this voluntary proposition mechanism can help CAD itself to come up with a solution in a more negotiated manner with companies. This was the first thing that drew my attention regarding compliance. And a second one is the provision that says that CADE and specifically this new unit within CAGI in charge of digital markets, will be able to conduct like market investigations, like market analysis that don't have a sanctioning purpose. So I think it's similar a little bit to what we're seeing with the DMA. So this was a very interesting innovation that I've seen in the new text, because I think in the end of the day, it will allow CAGI to check, for instance, if previous obligations are actually working. So I think it can kind of serve the purpose of working as a kind of an ex post assessment as well. So I think it's very interesting. It's another very interesting example that can help CAGI on enforcing the law and also in terms of securing.
Okay, that's really interesting, although I do have a comment on that. So the DMA does not really accommodate for market investigation. So it's more of the national competition authorities that are actually revamping this animal of market investigations in their national territory. So for instance,
I think that the MCC, I don't know if I said it.
the
I think
MCCA,
that
yeah,
the MCC,
It's
the
too much.
MCC.
We have too many similarities as well in terms of our digital rules. So you are excused. Thank you so much, Rafa, for joining us. For the audience, subscribe, like, rate the video if you'd like it. Also, drop any comments you might have in the comments below. I will also note every single development, and it will be quite long, I think, that Rafa pointed out when he was speaking. And I only wanted to thank you, Rafa, for joining us here in the Agora and sharing your experience and your knowledge in this really complex Brazilian legal landscape.
Thank you so much, Alba. It was a pleasure for me. And yeah, please continue doing everything that you are doing. I think it's super interesting. I really love reading your articles and, of course, listening to this podcast. And I'm going to continue to do so. So it was a pleasure to participate.
Thank you. Bye-bye.